Law Matters? Of course it does. Welcome once again. My name is Debbie Morais, your host and moderator. As we tell you, this long-running program continues to provide legal information, practical assistance to you as you handle law matters. As we say, the better you understand the law, the better you are in a position to defend yourself or retain outside counsel if you choose to. As we present various topics, we know that you may want to handle some yourself. We're here to help. As always, we want to welcome and thank Attorney David Bazar from the Bazar and Associates law firm in East Providence, who continues to provide his legal information and his insights and sometimes anecdotes on the various topics that we'll discuss. And today, expungement of criminal records. Who can and cannot have their records sealed and expunged? Who can, cannot, and why? All important issues to you. It's important to youth, their parents, adults who have any kind of criminal records. Those who don't know what this is about, who aren't aware of it, and don't have the means to have their records wiped clean, can have some choices removed from them that not necessarily they would have to. In the past, we've discussed the juvenile court system and how it differs from the adult court system. The system, of course, emphasizes rehabilitation over incarceration. But what about the record of that 15-year-old who made that bad choice? That may follow him far beyond the days of his serving a sentence or even just having a class or two. We're also going to discuss what happens to the records of decriminalized offenses. Jailed for weed possession no longer. Some people have that black mark affect their future job applications and other things that they would like to do. We think that having that record impact on your family life and your living is an important topic to discuss. It affects employment, housing, participation in your children's activities, even if perhaps you wanted to adopt a child or foster a child. So there are costs to it, there are values to it. We want to discuss the short and long-term value of both. Certainly the point is that the impact lasts far beyond the conviction. So let's start, David, with a definition of what expungement is and talk about the process. So take it away.
Sure. So when somebody has a criminal offense, they are charged, and oftentimes most cases are resolved with a plea, usually in Rhode Island, nolo contendere, and then whatever sentence the judge is going to give. The arrest itself creates a record when somebody's arrested. Even if there is never a plea or there's no conviction, there's still a record. So expungement of records, and we'll go through the details of all of this, but allows for certain people with certain charges to have the records removed from the public, so to speak. If they're expunged, they're still there, but they're confidential. They can't be released except for certain things in certain circumstances. And in Rhode Island, you can have your records sealed, which is a little bit more of a removal of the records from the system, harder to get to. And that's usually, again, for certain things where we talked about there might have been an arrest, but not a conviction or a dismissal of some type. And those certain circumstances, records can be sealed.
So before we get into the process, what kinds of convictions are most likely to be qualified to be expunged? I am imagining not first-degree murder or whatever,
right.
But...
Well, there are certain crimes of violence that under no circumstances can those records be expunged or sealed or wiped out if there's a plea to them. There's some domestic violence statutes that don't allow for a regular expungement for the removal of records. There's some process given the circumstances where they might be able to be removed, but not through the regular expungement statute. And there are time frames that apply. So let's just take the standard run-of-the-mill. I was a bad young adult and I had some criminal charges, misdemeanors, and I did my sentence, and now I would like to have that wiped out because I've grown up and I've been a good person. So traditionally the rule was in Rhode Island, if you had a plea to a misdemeanor of nolo and probation or nolo and even a sentence, once you completed the sentence, paid all the fines, if you were good for the next 5 years after the completion, you could file a motion to have the records expunged, unless it was one of the other statutes that we talked about that aren't allowed to be expunged. Felonies, other than felonies of violence, and there's a whole list of what those are and how you define those, felonies could be wiped out if you only were a one-time offender, youthful indiscretion, and served all of your sentence 10 years after you completed payment and serving the sentence. That could be wiped out as well.
So we are talking about the basics of this. I guess it's important to note that whose records, what kinds of records get expunged vary from jurisdiction to jurisdiction, state to state. And I guess right now, from what I've read, they are constantly being updated because more and more people are finding that there's need to do that. Many, as I've understood, didn't know that such an option existed. Some people who are disadvantaged aren't aware of it, haven't had that opportunity. So go through the process of what expungement means, and I think the other side of it is I'd like for you to address also, is that something that one could DIY, as we say?
Okay. So it depends on exactly what your plea was and what your circumstances are and whether or not there were any other charges. So Rhode Island actually has been a pretty forward-thinking state on allowing people to clean their records up. Because if you have a record, it has an impact on a lot of different areas. And you talked about some of them at the start, but can I be asked if I've been charged with or convicted of a crime when I apply for a job, when I apply for housing, when I apply for to help at a school where, as you said, my child is as a coach or whatever. So these things are things that you may or may not have to disclose, and if your record has been expunged, you may, if you had to before it was expunged, you may not have to disclose them in most circumstances after. So what Rhode Island did was we had people who had 2 or 3 charges early on in their lives of misdemeanors. Could they be expunged? Well, the rule originally was you had to be a one-time offender. So we expanded it in Rhode Island to more than one, up to as many as perhaps 6, where you've been out of trouble for now 10 years, when it's more than one misdemeanor, you could file a motion for expungement. So if you went to the Rhode Island website and looked up expungement, you'll find that there is a motion for an expungement and an affidavit that you have to file along with the motion for expungement. You have to send it to the Attorney General at least 10 days in advance of the hearing. You should send it to the police department where you were charged, and you'll have a hearing in front of a judge. So the question you asked is, can you do it yourself? You can. If you want to make sure it's done properly, you might want to hire an attorney to do it, because it's not only important that you follow the procedure to get it expunged, but also the procedure afterwards to make sure that it's sent to all of the appropriate agencies so that the record is then wiped clean or sealed or at least put under lock and key, so to speak.
Interesting that you mentioned it. Of course, I knew that you would. We had posted once during this session the riag.gov site for Rhode Island, and Mass has expungema.org, where people can at least get some insight as to, even if they're going to qualify, and whether it's worth it to reach out to a lawyer to help them. And it's very noteworthy that there are so many different agencies. Maybe you can help and list a few, but so many different agencies and organizations that need to have that final filed document, or it still will impact negatively on someone's life.
Yeah. So just to touch base a little bit on what you were just saying, there are those websites with the Rhode Island Attorney General, Mass, where you can fill out a form to see if you're eligible for an expungement.
Yes.
So it's an online process. That is definitely a do-it-yourself type of situation. You submit it. I assume they go through your record, take a look at it, and say, yes, you are eligible for an expungement. So when we were talking about filing the expungement, all right, so I was arrested in Providence, say, and I was a misdemeanor charge 10 years ago. And there was also a record at the district court because it was a misdemeanor. So you want to make sure that you go through the process and that the Attorney General is notified, and if they have noticed that the expungement was granted, the Providence Police, who have the original arrest record, and the Bureau of Criminal Information, or BCI, who's the custodian of those records, so that they can take it down and make sure that it gets taken down off of the public websites that are out there for the Rhode Island judiciary or wherever else someone may go and look up your records.
So is it true that even if you have that record expunged, that police still could have access to it? Suppose then you did commit another crime, and they find, well, see, he's done this before. And if it's expunged, should they really have access to that? Apparently, an expungement isn't completely an expungement. Some government agencies still can access that. Can you clarify?
Yep, that's true. And so here's the thing. For the most part, general living things that we need to do, get a job, most jobs, have a place to live, do certain other things. Your record, once it's expunged, never has to be disclosed and will never come up again. But there are other things, other areas where agencies and you have an obligation to disclose and be able to get those records. So as you said, I've been convicted of a crime after the original offense had been expunged. And once I'm convicted, the court then can look at your past record for sentencing. And when we look at your record, even the expunged record can be looked at to say, all right, well, what has his life been like? So we know what an appropriate sentence would be. Oh, well, he really had some of these offenses similar to this, that were expunged. So the judge is entitled to know that prior to sentencing.
Exactly. So interestingly, too, there's always such conversation and debate now about what's going on with immigration and deportation. And apparently, in some of those legal proceedings, this being one, if someone had committed a crime after having some expungement, that can have the under seal overturned and can weigh in on whether someone gets to stay here or whether they're going to be deported, even after the expungement if something has happened.
That's right. And there's also, if you are applying for certain jobs, even though your record's been expunged, the agency can find those, so you may need to disclose those. And for example, if you took the bar exam, passed the bar, and want to become a lawyer, part of the character and fitness is looking at your records. And you should disclose if you had records that were expunged, because the statute says that they can get those records. So you just need to disclose that in that circumstance. Also, if you're applying to be a law enforcement, a police officer or something, again, those records can be found even though they've been expunged and probably need to be disclosed. In certain jobs with early education, young children, or coaching, you need to disclose it because they can be found under those circumstances as well.
To digress perhaps just a little bit, it does make sense, whether you're a lawyer applying to be a police officer, it always makes sense to not start out that job application with a lie, which is when you're asked outright, have you ever, to lie is not a good thing. But also, if you are in that situation, there's much to be said for you having a paragraph or an explanation or a context in which to set that story straight and add to it, and also even to have letters of recommendation that somehow can be added and as an offset at some point.
Well, here's the thing. It should not be a check the box on an application, I've been convicted of a crime or I'm charged with a crime. It should be, and in those situations, is a chance to explain. So when you're filling out the application to be a police officer or the application to become a member of the Bar Association as a lawyer or whatever, I was charged and convicted of such and such a thing when I was this age. That record has been expunged. And just put it right in there. The fact that that record has been expunged is somewhat of an explanation to whomever you're applying to that you have turned around your life, because when the court looks at your motion for expungement, there is some discretion within the judge whether or not to grant your motion, and part of what you have to do is show them that you have either rehabilitated your life or changed your life, or you've lived as a contributing member of society and have done good things and have not been charged again with anything because you're living a good life. So that should be taken into consideration. And so when you say that record was expunged, the agency you're applying to should know what that means.
Quick point here, I guess we should mention, or you should refer to, expungement is not the same as a pardon for what had been done, correct?
That's correct. Yeah. And a pardon doesn't say that you didn't commit the crime, but that you are pardoned from the consequences of whatever it was. And we know a lot about presidential pardons. Governors have pardon powers too. I don't think they're often granted or even applied for in Rhode Island.
Good to know. So when someone has had the expungement and records are partially sealed, important to note that it's not going to show up then in general background checks. Is that true?
General background checks, that is correct. It's supposed to be confidential. The holder of the records actually could be subject to a penalty for releasing records that shouldn't be released. And there's only certain exceptions, which we talked about most of them already. But other than those exceptions, those records are not supposed to be released. And that's the whole point of it. It's to give somebody a chance to go and get a job, to be able to vote. There's also rules on voting, and we didn't talk about deferred sentences either, or decriminalization, which we can get to. But the point is that if your record has been expunged, for most circumstances, you don't have to say that I was convicted of a crime, and the people that you're applying to a job for a tenant in a landlord-tenant situation aren't entitled to know.
There are plenty of obstacles for those who want to have an expungement. Some of them can't afford it. Some may not even know that it exists. But even for those who have known about it, have been able to pay for it, it's probably important to note that despite what happens with an expungement, thanks to the news media, social media, those records or notes or comments on what has happened may never truly be erased and may be out in the public domain anyway. And that has nothing to do with our legal system that we're focusing on right now. But once something has happened in the world, news and social media have made that forever a record that can be sought after if someone cared to.
Yeah, different situation, different issues. It's something that we've often talked about before is when you put something out on social media, you can't really get it back. And so it could be out there, it could be found, but it's different than the legal system and the records that are kept by the police and the courts and the Attorney General's office. Those records, once they're gone under expungement, for the most part, you don't have to disclose them. And an employer, a potential employer who would file a background check perhaps, isn't going to find those records through the normal system that they'll look through.
And it's good to know. As we talk about now the cost of it, I hope you will address that in a moment, but in doing this preparation, it was very interesting to find out that in various states, they have various kinds of restrictions that will accompany your having a criminal record. In one state, not ours, not Mass, not Rhode Island, 958 restrictions based on a criminal record. I can't even imagine enumerating those, but that certainly says that is pretty wide-reaching. We think about housing and employment and what might happen in your school and family community life, but that says that there's some serious significance about the issue of expungement. What does it cost, and what do you think about that, David?
The cost, it depends on what is involved in it. If it's a straightforward misdemeanor, go to district court, get it expunged kind of thing, most attorneys probably would charge around $1,500 to $2,500 to take you through that system. You might be able to, if you can't afford that, contact, for instance, in Rhode Island, the volunteer lawyer program. You might be able to get an attorney if you don't have the means to pay for one, or the reduced fee program as another option. So if you contact the Bar Association, you can probably get an attorney to help based on your financial circumstances. Could you do it yourself? Perhaps, but I would always recommend, just like I always do, for any time you're going to court and need to be in front of a judge who has discretion over what to do with your case, you're probably better off to have an attorney represent you in that circumstance.
And you know, we have spoken of that often, most recently when we were talking about the juvenile cases. Is it customary that if you are representing someone, child or adult, that if it is a misdemeanor and the person's had good character, good, clean, clear record, that when you're having sentencing, that you'd offer or you'd ask for an expungement right at the time of that sentencing? Would you likely do that? I've read of cases where there are times, once this time is served and the restitution made, that you can clear it, seal the record, expunge it, or whatever. Does that happen,
Okay.
David?
So there are certain cases. Let's talk about the juvenile cases. So juvenile cases, those records are supposed to be confidential. Again, there are certain exceptions. For example, if you got in trouble as an adult, the judge who's going to sentence you, if you've been convicted, can look back at your juvenile record, if there is one. And there are certain other law enforcement or other type of situations where your juvenile record may be looked at. But for the most part, juvenile records are supposed to be confidential, and you don't really have to do anything to expunge or seal them. There are other cases, a misdemeanor, where you might be sentenced in Rhode Island to a filing, they call it. They put it away for a year. You stay out of trouble for a year. At the end of the year, it's over, and that's supposed to now be automatically expunged or sealed after the end of the year, removed from the records. I would check that if I were the defendant to make sure that it can't be found. And if it can be, I would contact an attorney to say, hey, can you help me figure out why this isn't gone and make sure that it goes. If it's a domestic violence case, it wouldn't be 1 year, it might be 3 years, but for the most part, most filings are 1 year. We have something for felonies called a deferred sentence in Rhode Island. And a deferred sentence is like a filing in the district court and superior court. They give you a deferred sentence with certain conditions. You meet all those conditions. At the end of 5 years, you can now file to have that expunged. And you do have to file and have a motion to have it expunged. And there was a little bit of confusion over what the rules were for that. So the legislature changed it, I forget, maybe 2016 or around that time, to say that yes, at the end of the 5 years of a deferred sentence, you can file a motion and have it expunged if you've completed everything. The other thing we didn't talk about was decriminalization. You want to talk about that?
Sounds right. Just one other thing I want to ask you about that deferred situation. While there's a deferred plan in place, is that still impacting someone's ability to vote, obviously carry a firearm, and some other issues? Can you, where does that come into play, David?
So for the most part, the right to vote in Rhode Island has been changed a little bit so that you're only prohibited from voting while you're incarcerated. So a deferred sentence doesn't involve incarceration, so it should not affect your ability to vote. And as far as firearms and that type of thing, it depends somewhat on what crime you're charged with. If it's a domestic violence, for example, you can't have a firearm. You have to turn those over. And there are other things like that where you cannot have a firearm. But the conviction of on a case where it's not really, like, for example, NOLO with a probationary period isn't considered a conviction for some purposes.
Good to know.
So yeah, have I been convicted of a crime, NOLO, and probation? No. I've been charged with a crime, and the record will still be out there, but not convicted for civil purposes. For criminal purposes, they don't care. You plead NOLO, it's the same as pleading guilty. So if you do something afterwards, they're going to look back and say, oh, you did this. Look, well, I said NOLO. No, it doesn't matter. It's still a conviction. But for civil purposes, not a conviction. So for voting, if you're not incarcerated, you should be able to vote.
Good to know. Important points to check out. Many people might not know that. The other big and overarching comment that we haven't had a chance to really explore is decriminalization. And the first one that comes to mind, obviously, is weed. Because there was a time if you had a joint, you get caught, there's no end to the trouble.
Right.
How has that, you can use that as an example perhaps, but how does the decriminalization of offenses impact on this?
Yeah, so again, if you've had charges of possession of marijuana in the time when it was a criminal record that was created, you could file an expungement and have that removed from your record. There's a few other types of cases that they've decriminalized. Driving on a suspended license for the first offense used to be criminal. It's now civil. It's a civil offense like a speeding ticket. So you could move to have that removed from your record.
Good to know. And those who've had a decriminalized offense, do they have to go through the same procedure if it's been a certain number of years? Because retroactive, how long is that retroactive? That's my question.
Yeah, so if you would, it is retroactive to when you, in the sense that when you were charged, it was a crime and now it's not. So since you have that now in effect, the statute says that you can have it expunged, and there's a process. I haven't looked at that one closely, but I know that you can have the decriminalized record removed since it's no longer a crime.
And there seems to be state to state some significant differences between a sealed record and a expungement. And I believe it's even in Massachusetts that there are cases where it would be ill-advised to have a sealed record. It would be better if you could get an expungement if you qualify. How might that apply, David? Does that?
Yeah, and vice versa, depending on what it is.
Can you explore that a little?
I know in Rhode Island that you can have records sealed that you weren't convicted of. So there was a charge, you had a trial, you were found not guilty. Perhaps, depending on what the charge is, it could be sealed. And my understanding is that sealed records are more difficult, actually, to get records of than an expunged record. I'm not sure if it's the reverse in Massachusetts or not. It may be. It may be,
because as I was reading about it, state to state, they have very significant differences. So it may be just the opposite in another state.
It might be. And I'm assuming that since you can only get the record sealed in Rhode Island for cases where you're not actually convicted, that perhaps is a better thing, but I'd have to take a look at that to be sure. But certainly, you have to look at it state to state, because every state, their requirements and rules are a little bit different.
Right now, because this is an issue, there are restoration of rights projects that are going on across the country in various jurisdictions. Some are more active than others. Those organizations are trying very hard to make sure those who wouldn't have access to this information and the process, which, as I understand, that application process can be quite arduous, they're trying to make a concerted effort to help those who are likely to be disadvantaged. Hate to say that there are things that are racist, but there are issues, there are times when some communities are just not having as much access as they should. Good to know that because of that, and expungement having such impact, more and more are trying to help those who have lack of access or a shortage of it anyway.
And Rhode Island's been very active in the restoration of rights.
Good to know.
So there's actually probably, I think you could Google this too, and someone in the governor's office who might be able to be helpful with what your rights are. And so that might be a place to also reach out in addition to checking that online Attorney General website.
So we had 2 websites up. Thank you very much for tuning in to The Law Matters. As we say, it matters to you.